Hello everybody. Today we're going to talk about employment discrimination. Now I will tell you that employment discrimination, obviously we're talking about mainly involving teachers and other employees in the school district here. And when we're talking about employment discrimination, we're really talking about federal laws here that impact employment discrimination in one form or another. And these are the main federal laws that we will see impact employment discrimination. First of all, the 14th Amendment, which should be no surprise because we've seen that in all of our cases at one time or another. Here, specifically, the Equal Protection Clause of the 14th Amendment, which says, nor deny to any person within its jurisdiction the equal protection of the laws. And when we're talking about equal protection of the laws, we're talking about the federal statutes that Congress has passed. And the main ones here are Title VII of the Civil Rights Act of 1964, the Age Discrimination and Employment Act of 1967, or ADEA, the Americans with Disabilities Act of 1990, or ADA. These three protect against discrimination based on race, color, sex, national origin, religion, age, and individuals with disability. Now, just to break them down a little bit more for you, Title VII of the Civil Rights Act of 1964 says there's no screening for employees for hiring unless there's a demonstrable job performance reason. In other words, you can't use a test against employees to see if they could qualify as an initial screening exam unless that test is used for a demonstrable job performance reason. An example here would obviously be passing the teacher state licensure exams. Those have been shown to have demonstrable job performance reasons, and therefore teacher licensure exams are constitutional through Title VII because of that reason. What people have to show for Title VII violation is disparate treatment or impact in regards to practices. Treatment's a little bit easier to explain and to show. This is simply the mistreatment of people because of their race, color, religion, sex, or national origin. And again, that's obviously easier to show. What's tougher to show, though, is the impact. And disparate impact refers to, on the surface, neutral treatment that falls more heavily on one group than another, and that this cannot be justified for business necessity as related to job performance. So it's a little bit hard to explain here, but like I said, the treatment is easier because it's obvious. The impact might be something like, if a school district recruited only from schools that were predominantly white. If they were in an area where there was historically black colleges and universities, and they never went to recruit from those places, then on the surface that seems like a neutral treatment because the school is just recruiting teachers. But in reality, what that does is creates a disparate impact in that the district may receive less qualified teachers. So that's an example of how that works. Like I said, that's a little bit tougher to prove, but certainly is actually there. It's just that people usually don't realize what is happening. In 1991, Congress again passed another Civil Rights Act. This Civil Rights Act did the following things: appropriate remedies for intentional discrimination and unlawful harassment in the workplace, Adverse impact is unlawful when there is an available alternative employment practice that will produce a less discrimination. And the right of sexual discrimination victims to sue when intentional discrimination. So you can see that the Civil Rights Act is just redefining these things a little bit more each time they're passed. And Civil Rights Acts go back to after the Civil War, and we'll see one in here later on that was passed in the 1860s. But they're just passed periodically, and each time they redefine a little bit of the previous law. So rights in public employment, some more federal statutes that deal with public employment: the Equal Pay Act of 1963, Equal Pay for Equal Work, and we'll talk about that a little bit. The Immigration Reform and Control Act. This made it illegal to hire undocumented aliens. The Civil Rights Act of 1866, I told you we'd look at one of these from the 1860s. This law, still in the book, said all persons the same rights to make and enforce contracts as enjoyed by white citizens. And Title VI of the Civil Rights Act of 1964, this was an important law because it really connected with Title VII of the Civil Rights Act, discrimination, because the Title VI part is the distribution of federal funds. And so basically what happened in the courts is that anybody that was receiving federal funds through Title VI, then subsequently the federal courts could step in and say, well, if you receive federal funds, then automatically Title VII applies to you. And that was further elucidated on when the courts looked at one program. If one program received Title VI funds, does that mean that a whole district is under federal guidelines as stated in Title VII and other federal statutes? And the court said yes. And so now we see that anybody who receives any federal monies through Title VI or any other title program has to be compliant with all the federal statutes when it comes to rights in public employment. And through Title VI, we can deny federal funding to those who discriminate against certain individuals. Title IX, many of you are obviously familiar with Title IX, dealing with gender discrimination. Title IX came with the iteration of the ESEA Act of 1965, which of course now today we know is No Child Left Behind, but in 1972 there was the Title IX added to the iteration, and this obviously brought gender into the arena. And in 1993, the Federal Medical Leave Act said that an employee who meets certain qualifications can take 12 weeks of unpaid medical leave. And we'll look at that as we finish this presentation. The Employment Retirement Income Security Act of 1974 established fiscal responsibility for benefits and pension plans. This looked at the fact that women live longer than men, and therefore some people thought that women should pay more than men. And the Employee Retirement Income Security Act said, no, this is a violation, or the courts interpreted that and said, no, this is a violation based on gender. A few more here. The Veterans Reemployment Act, full reinstatement of their former employment. Veterans, if they have to be deployed. OSHA, or the Occupational Safety and Health Act of 1970, set minimum standards for job health and safety. Also established a whistleblower provision. Now, a prima facie case means that there is enough evidence to present a case and go to court. The things that must be in place for a case to be considered a prima facie case are the person has to be a racial minority or protected class. So it could be a woman, somebody who's disabled. The person must be qualified for the job that was being advertised. The person must be rejected even though they qualified for the position. And here's the key in any of these cases, whether we're talking about discrimination based on age, gender, disability, or whatever. Here's the key. The position must remain open and the employer continue to seek applicants with the same qualifications. So if you are a member of a racial minority or protected class, you qualify for a job, you apply for the job, you're rejected even though you're qualified, and they continue to advertise the position with the same qualifications, then you have a prima facie case for discrimination. The employer has to articulate some legitimate, non-discriminatory reason for the employee's rejection. And so and I say this to you as an administrator, as a principal, you will be responsible for reviewing applications for teacher and other staff positions in your building. So just keep that in mind as you're going through applications. Whenever you, what I would say is that whenever you disqualify a person's application, that you articulate on the application for your own records why the person was disqualified, and you move to somebody else. That way, if any question ever came back to you, you would have that handy, and you wouldn't have to rely on your mind to remember what you were thinking. Certainly, I would not rely on my mind, so I would suggest you do the same. Affirmative action. We've all heard of affirmative action and what it means. A voluntary plan adopted to remediate past discrimination, if not justified, may result in unlawful reverse discrimination. So affirmative action is the idea that we're going to hire minority or underrepresented populations to help remediate past discriminations against these specific groups of people. Title VII attempts to make hiring practice neutral and does not require an affirmative action that favors anyone over another. So an affirmative action plan, this would be in a larger district probably, not so much in a rural district here in Oklahoma. But an affirmative action plan can work, but it cannot favor any particular person over another. Okay, it's really used to highlight areas of weakness in your employment. It cannot be used though to select groups specifically because they are underrepresented. An affirmative action plan is not it is not unlawful to have a plan if statistical disparity between races and gender in a particular job category exists. So these are reasons why you can legally have an affirmative action plan. Okay, if you can show there is statistical disparity between the races and gender in a particular job category, if you're guilty of past discrimination, if it does not unnecessarily trammel the rights of non-minority employees. In other words, if it does not necessarily disqualify non-minority employees, does not stigmatize non-minority employees, and the plan is temporary and terminates when a balance is achieved. So affirmative action plans can exist, but they are not exactly what people would initially think of them as saying, well, if two equally qualified people are here, I automatically have to hire the minority or underrepresented person. So just keep that in mind, okay, when people talk about affirmative action plans. Sexual harassment in the job place. Sexual harassment can range from verbal innuendos to overt sexual acts. the EEOC regulations that do this, and the EEOC is the federal agency that oversees all the discrimination criteria here. The Equal Employment Opportunities Commission, it's a federal agency in Washington, D.C., and my mother used to work with the EEOC in Fort Sill in dealing with cases brought against the federal government at Fort Sill. The EEOC, and you will notice that a lot of applications, somewhere in the fine print, will mention EEOC compliant or something to that effect. The EEOC regulations state that sexual harassment consists of unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of the sexual nature. When one of the following is involved, then sexual harassment can be said to have taken place. Submission required explicitly or implicitly as a term of employment. When decision is used as a basis for an employment decision, interferes with work performances, or creates a hostile work environment. And that hostile work environment is really key here, I think, because all these others deal with, in my mind, all these others are dealing with you as a principal in your hiring practice. But that last bullet there, interferes with work performance or creates a hostile work environment, this actually gets into the day-to-day activities of the work environment, not just your hiring practices. And so that hostile work environment needs a little bit more light shed on it here. So when we talk about an abusive environment, it is determined by a number of factors and frequency of incidences. The employee does not have to prove actual psychological or otherwise harm. If these things are continuous, the law talks about psychological or otherwise harm, but to say that sexual harassment has created a hostile environment, the employee does not have to prove this psychological harm. The employer is held responsible to a standard, and the standard here is, did they know or should they have known what was happening? If they did not know and were not made aware and should not have necessarily known, then they can be exempt as long as they take immediate and appropriate corrective actions. Where employers or districts can become in trouble is if they did know and did not take those immediate and corrective actions. That's where a school district can find itself in trouble with sexual harassment in the workplace. And so this would really come to you probably, again, this is going to be in two areas: in your hiring practices, but beyond that, in your work environment, where an employee is claiming sexual harassment and it's creating a hostile work environment because of that. Religious discrimination. Religious discrimination, of course, is protected by the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And that's where religious discrimination comes into play. The standard here is to reasonably accommodate somebody for their religious preferences. And the courts have ruled that there can be no undue hardship put on a company because of a religious accommodation. An example would be the book talked about an airline worker who asked to be scheduled off on Saturdays because Saturdays was his religious holiday, and the airline said no. The worker sued under religious discrimination, and the court said that it would be an undue hardship on the company to schedule Saturdays off for their workers who did not work on Saturdays. So that's an example here. You cannot make a person choose between a tenet of faith and a job. Really, in Oklahoma, where I would see this coming into play would probably be dealing with Wednesday night activities. I mean, you know, that's really the bottom line where you're going to see this. And as an administrator, I tried everything I could to schedule things off of Wednesday nights, especially extracurricular activities such as basketball games, simply because living in Oklahoma, that's what we do. And on a side note, you know, that idea of Saturday being a religious holiday, you may come across that just a little bit in Oklahoma, especially in the urban areas, where people who are either Jewish or Seventh-day Adventist may request to be excluded from Friday duties, Friday evening duties, and that would be something I would say to consider. Chances are, if you hire a coach, coaches are going to realize this is something that is required of them. So it would probably be workers that you would be asking to work. And I would simply say substitute a different day for them and give them their Fridays off, okay? And go with it from that. I wouldn't question them and make them prove that they're Seventh-day Adventist or Jewish. Age discrimination. The rational interest test. Initially, the law said that age discrimination would apply to people between the ages of 40 and 70. That law was changed to state between or anybody above 40, and so it becomes a test later on as to whether or not the person is too old. And the bona fide occupational qualification here, what the courts have said in regards to this is simple. They've ruled in favor of laws that, for example, ask firefighters to retire at the age of 50. The reasonableness necessity here is that a firefighter at the age of 25 is more fit and can do better than a firefighter at the age of 55, and so the courts have accepted those kinds of stipulations on age discrimination. And those are what we call bona fide occupational qualifications. Okay. Disability. Americans with Disability Act excludes the coverage of illegal drug use disorders from current illegal use of drugs. So you cannot qualify for disability by using, if you are a drug user or if you have a disability related to drug use. Many other specific acts and behaviors. It does not include, I think that the law specifically said it excludes things like homosexuality, pedophilia, transvestism. I mean, there's a whole list of things that are excluded from the American with Disabilities Act. In other words, the federal courts are saying that these things are not disabilities. It does include mental or physical impairment that substantially limit a major life activity, one with a record of such impairment, or one who is regarded as having such an impairment. And here's the thing with the American Disabilities Act. Once you're classified as having a disability, then as long as you can perform the duties asked of you, you cannot be discriminated against. Okay, so again, as the employer, this is going to come in a couple of situations. First of all, in reviewing job applications, if the person can still perform the duties, then you cannot disqualify them from their the job pool simply based on their handicap. If the person, the second area of this would be if you're a principal and you have a teacher who develops a handicap, and let me give you an example of that, a real life example. I worked with a teacher once who was diagnosed with post-polio syndrome, and at the beginning of the school year, she was fine and she could walk around, but by the end of the school year, she had to use crutches to get around because she was unable to walk. And so she had a diagnosis that was recognized as post-polio syndrome, but she was still able to do all her duties as a teacher, and she said that she did nothing during the summer, that she used summer times to recoup and to rejuvenate, and probably by now I guess that she's retired, but so that's an example of how a disability exists, but it does not impact her ability to teach the class, okay, because she was able to still teach the class even though she used crutches. What has to be shown is that a disability has to affect one of life's major activities, and this is what the court has said. And so these are what the court deems as affecting or as life's activities: caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. So if you have a disability or have an employee with a disability, as long as they can still do life's activities, then you cannot show any kind of favoritism or negativity toward that person. The major standard here that we use in looking for employment is the otherwise qualified statement, with or without the accommodation. In other words, would this person be qualified without any accommodations? And if that's the case, then you have to be able to make those accommodations, okay? In the case of the teacher, if the teacher were not able to fulfill her duties, then that would not be otherwise qualified, okay? Unless accommodation creates an undue hardship. And here, in regard to education, I would think that the undue hardship would probably be the idea of the teacher not being able to fulfill his or her contractual duties. In other words, not being able to come to school and deliver instruction. And this also leads into the Family Medical and Leave Act. The Family Medical and Leave Act, which was passed in '93, I believe, states that a person can take off for 12 weeks of unpaid leave per year, and can take it in one lump sum or intermittently to take care of a child or a dependent. But the courts have stipulated specific things in regard to education on the FMLA, and specifically it talks about the fact that a teacher who takes off at the end of the year would create an undue hardship, okay? And so you can see how these overlay each other or overlap each other. So those are the big laws dealing with employment discrimination. Again, I think that when you're dealing with employment discrimination, you're probably looking at this at two levels, and that is you as a principal hiring somebody and being cognizant of employment discrimination in your hiring practices. And then the other level, and probably less likely to occur depending on the district in which you find yourself working, but the other one is the actual employment discrimination taking place within the workplace once your people are hired. So hopefully that gives you some insight into the various federal statutes that affect the states when it comes to employment discrimination.